Good afternoon and welcome to today's presentation, Law Enforcement, the Use of Deadly Force. In today's webinar, Mr. Taylor will discuss force terms, target, tool, and time variables, interactions with the offender, reports, and restraints. To give you a little background about our presenter, Roy Taylor, he is a professional law enforcement manager with more than 30 years of experience in a wide range of federal, state, local, and private criminal justice positions. He has experience with training, use of force, and firearm instruction, recruiting, employee supervision, canine utilization, emergency management, and more. Attendees who require a passcode, the word for today is force. During the Q&A session, we will ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You are also required to complete the survey at the end of the program. Tomorrow morning, we will send out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list to the left of your screen. Thank you all for attending today, and Roy, the presentation is now turned over to you.
Thank you, Emily. Good afternoon. It's Roy Taylor. I appreciate your attendance today. As you know, the use of deadly force or force in general in law enforcement has been in the news media quite a bit over the past 2 years. So I think this is a relevant time to look at this topic, depending on how you're involved with it, whether you're a plaintiff in a civil suit or an attorney for a law enforcement agency, or like me, an expert witness that could be on either side of the bench. I'm sure that you'll get a little bit of something out of this. If you have any questions, please type them in as we go through. And if we can't get to all the questions before the end of the webinar, I will personally email you with those answers as we finish up today. The slide for training objectives, the first training objective is we're going to look at the two significant cases and use of force, and that's Graham versus Connor and Tennessee versus Garner. And we're going to watch a small videotape on each one of those where they actually reenact it for you. We're going to talk about the concept of target, tool, and time, and this is just a new teaching strategy we're using in law enforcement to help break it down for the officer. It also assists them with writing their reports. We're going to also talk about the need for those reports and how the details need to be included initially so that when this does go to trial, the trier of fact as well as jury members or whoever else is going to be looking at this will have all the information they need to make a decision. And also we're going to be talking about how that language needs to be consistent with not only the law but also the agency's policies and training material that the officers have been exposed to in their career. Sorry for the delay. I have to wait for my computer to spool up as well. Federal law authorizes use of force in arrests. We know the Fourth Amendment talks about illegal searches and seizures, and also the 14th Amendment and how that applies to us in due process. The primary federal laws, of course, are Title 42 and in Section 1918 and Title 18, Sections 241 and 242. Of course, we can use arrest to prevent the escape from custody. If an officer is going to make an arrest, he has a right to use force to overcome any resistance from the arrestee or defendant. He can also defend himself or a third person from what he believes is going to be the use or imminent use of physical force while he's trying to attack, to make the arrest or prevent a person from escaping. In the use of deadly force, there's 4 situations where they're allowed to use deadly force. And of course, the most obvious would be to defend himself or a third person from what he reasonably believes to be the use of imminent deadly force or force that would cause serious bodily injury. And we'll talk about those definitions a little bit throughout the webinar. But the word reasonably is the thing that everything always hinges on. And so we have to look at what that officer was experiencing at the time that he used force. And the decisions that he makes, were they right or wrong, but we have to look at it through his eyes with his amount of training. Everything has to be the same in order for this to be fair. Looking at a situation in the nice sanctity of the judge's chambers doesn't always reflect what the officer was going through. So we want to make sure that we're putting ourselves in his shoes and through his experience looking at what he was dealt with. There's many times where what the officer perceived to be a deadly force threat turned out later not to be. Maybe the subject didn't have a weapon, but making a furtive move like he did, but it could still be a justified use of force. He can also use deadly force to prevent the escape of a suspect from custody who he reasonably believes is attempting to escape by using a deadly weapon. So if the person has what we normally consider a deadly weapon, a knife or a firearm, or it could be any item that he's been able to pick up and use as a deadly weapon, such as a rock off the ground or a broken piece of glass, a tree limb. It doesn't matter, but if it's something that can cause serious bodily injury or death, then the officer would be able to use deadly force against them. We can also use it to effect an arrest or prevent escape from custody of a person who by his conduct or by any other means indicates that he presents an imminent threat of death or serious physical injury to others unless apprehended without delay. I always call this the Hannibal Lecter exception. If you remember the Silence of the Lambs movie, Hannibal Lecter was a doctor that would go around, kill people and eat them, make a nice meal and have a nice wine and serve it to his guests. But in reality, I think maybe if you have a domestic violence protection order and the defendant has been violating that order, and by his conduct and his threats that he's going to cause death or serious bodily injury to his estranged spouse, then this may be a situation where if he's on his way there and you try to stop him and he is resisting your attempts to stop him, you may have to use deadly force. Sometimes those situations are that violent, and the person wouldn't even have a weapon at that time. And finally, we call this the Department of Corrections exception to prevent the escape of a person from custody imposed upon them as a result of a conviction for a felony. Most law enforcement officers wouldn't know what the situation is. If they see somebody in a green jumpsuit running away from a prison van, most of the time they're not going to use deadly force unless they feel threatened. But that's why we see the Department of Corrections officers with shotguns when they're out with road crews or manning the guard towers, that they would actually be able to use deadly force to prevent the escape of a fleeing felon from custody. We mentioned the two cases relating to the use of force. The first one is Tennessee versus Garner, and that was a case that involved a fleeing felon, and also Graham versus Connor, which talked about what a reasonable officer would do with limited information in a quickly unfolding circumstance. So again, we're going to take a couple minutes and watch these reenactments of these cases. The first one will be Tennessee versus Garner.
One of the most pivotal cases you will ever encounter involving the use of deadly force by law enforcement officers is going to be the United States Supreme Court decision in the matter of Tennessee versus Garner. That was a 1985 United States Supreme Court decision, but we need to take it back to 1974. In Graham versus Connor, you have a Charlotte police officer. An officer by the name of Connor in the Charlotte Police Department was...
Go back to Tennessee versus Garner and see if it'll play for
One
you.
of the most pivotal cases you will ever encounter involving the use of deadly force by law enforcement officers is going to be the United States Supreme Court decision in the matter of Tennessee versus Garner. That was a 1985 United States Supreme Court decision, but we need to take it back to 1974 to get a full flavor of exactly what happened that day. It's October 1974. Officer Hyman, Officer Wright with the Memphis Police Department were dispatched to the scene of a call for a prowler. When they arrived at the scene, a neighbor is on the porch. She told Officer Wright and Officer Hyman that their neighbor next door was gone. Nobody was supposed to be in the house, yet she heard somebody rummage around in the house. In fact, she heard them at the current time when they had arrived. Officer Wright stayed on the porch to talk with the neighbor. Officer Hyman left the porch and walked to the back of the neighbor's home just to investigate the matter.
and he sees what he believed to be someone who was between 17 and 19 years old, a black male who's fleeing from the rear of the residence toward the back fence. When he announced his presence and yelled halt, what he said was a crouch. The person crouched at the base of the fence and then leapt to the top of the 6-foot fence to go over it. He had unholstered that revolver at the time and initially had stated that what he fired was a warning shot.
The round struck the suspect in the back of the head. He later died. This individual, it turns out, was 15 years old, 5'4", and weighed between 100 and 110 pounds.
And I believe that the initial knee-jerk statement by Officer Hyman was correct. I think it was a warning shot that just went awry. The planets lined up, everything that could have gone wrong went wrong, and he struck this child in the back of the head for $10 out of a pocketbook inside the home.
The interesting part about this fact scenario is that Officer Hyman was acting at that time in conformity with Tennessee law. Tennessee law in 1974 justified and authorized the use of all force, to include deadly force, to stop the escape of an individual on which you had probable cause to believe had committed a felony. This was the aspect that the United States Supreme Court took up. When the United States Supreme Court evaluated this matter, their first determination was whether or not a seizure of this suspect, Garner, actually took place. They concluded that yes, indeed it did. A seizure under the Fourth Amendment to the United States Constitution took place whenever his movement was stopped. In this case, it was stopped by the use of deadly force. The second evaluation was whether or not that was an appropriate application of force. The United States Supreme Court concluded that it was not, that the use of deadly force against a nonviolent, non-threatening suspect who you had probable cause to believe had committed a felony was constitutionally unreasonable. In fact, the United States Supreme Court had a quote that I'd like to read to you now. The use of deadly force to prevent the escape of all felony suspects, whatever the circumstances, is constitutionally unreasonable. It is not better that all felony suspects die than that they escape. Where the suspect poses no immediate threat to the officer and no threat to others, the harm resulting from failing to apprehend him does not justify the use of deadly force to do so. It's no doubt unfortunate when a suspect who is in sight escapes, but the fact that the police arrive a little late or a little slower afoot does not always justify killing the suspect. A police officer may not seize an unarmed, non-dangerous suspect by shooting him dead. That was the ultimate conclusion of the United States Supreme Court. Having said that, did they make allowances for the justification of deadly force in appropriate circumstances? They did indeed. They further went on to explain when deadly force could be authorized. Where the officer has probable cause to believe that the suspect poses a threat of serious physical harm, either to the officer or to others, it is not constitutionally unreasonable to prevent escape by using deadly force. Thus, if the suspect threatens the officer with a weapon, or there's probable cause to believe that he has committed a crime involving the infliction or threatened infliction of serious physical harm, deadly force may be used, if necessary, to prevent their escape, and if some reasonable warning has been given. Under those circumstances,
Okay, I'm told the video has stopped playing, still playing on my end, but we'll go to the next video, which will be Graham versus Connor.
in Graham versus Connor, you have a Charlotte police officer. An officer by the name of Connor in the Charlotte Police Department was on routine patrol. He happens to observe a car pull up at a convenience store. In this car were two individuals, a driver and the passenger. The passenger was Graham. Graham was in the process of having a diabetic reaction. He needed sugar. He had his friend drive him to a convenience store where Graham got out. Graham went into the store intending to buy a bottle of orange juice to help him with his diabetic condition. When he got into the store, he was antsy. He wanted to get the orange juice as quickly as possible. He saw an extraordinarily long line in the convenience store and simply could not wait. He immediately ran back out of the store and into his friend's vehicle. Officer Connor, observing this behavior, thought something was suspicious, knew that something wasn't right, but he just did not know what. Officer Connor followed this vehicle. He followed it for a few blocks. He subsequently initiated a traffic stop to investigate exactly what was going on. When he pulled the car over,
cases, just in case you're not familiar with them, but Tennessee versus Garner, basically the Supreme Court came out and said that you cannot use deadly force or against a fleeing felon. So in this case of Tennessee versus Connor, or Tennessee versus Graham, they shot a young male that was fleeing from a home that he was burglarizing, and he had no weapon. He died over stealing $10. So the Supreme Court said that that wasn't reasonable. At the time, Tennessee law did authorize police officers to use deadly force against fleeing felons, and it didn't differentiate what type of felony it was. So in this case, it was a burglary suspect, but you could reason that a fleeing check forger could also be shot by the police at that time. The next case that we were going to look at was Graham versus Karna, which was a Charlotte, North Carolina case. In that instance, a Charlotte police officer was sitting in the parking lot of a convenience store, and he observed a vehicle pull in a hurried manner, and the passenger jump out of the car, go inside. He could see the man running around in the store, which seemed kind of unusual. He exited the store in a hurry, got in the vehicle took off in a hurried manner. The police officer pulled out behind the vehicle, initiated a traffic stop. At that point, the passenger got out of the vehicle, ran around the car twice, and then ran over into a field and fell down. The officer waited for backup to come. They went over, picked up Graham, picked up Mr. Graham and brought him back over to the police car. And that manhandling of the subject, they injured his shoulder, injured his ankle. He got roughed up a little bit. One of the officers said that he'd never seen a person that was a diabetic act that way, but while they were searching him, they found a card in his pocket that indicated he was a diabetic. The officers then unarrested him, took him home, and of course they didn't handle the situation properly. It went all the way up to the Supreme Court, looking only at was the officer authorized to initiate that traffic stop when he had no other evidence of any crime taking place. And the court said that the officer was reasonable in what he was doing. It turned out that Mr. Graham had simply stopped at the convenience store. He felt that he was going into some type of diabetic shock. He wanted to get some orange juice. He went inside the store, got some orange juice out of the cooler, went over to the checkout line. There was too many people ahead of him. He thought that he would be able to make it home. He put the orange juice back and got in the friend's vehicle and took off. So what he was doing was reasonable. Obviously, he wasn't thinking all the way clearly, or he could have drank the juice while he was waiting in line. But anyway, that officer saw what looked to him like possibly a robbery or some type of larceny had just occurred, and that's what his perception was. And then when he instituted the traffic stop, and the person got out and ran around and then passed out, he thought that he probably had somebody that was impaired on some type of a drug. They made mistakes with not properly taking him in front of a judicial official and releasing him and treating him for his injuries, but that wasn't addressed in the Supreme Court. The court just said that because these events are so quickly unfolding that we need to look at them through the officer's eyes and base that on that officer's experience. So if it was a rookie officer, you could say that they may be given a little bit more allowance for something they did than if it was a veteran officer with much more experience and training. But that was the two cases that come up in use of force quite often. On the slide that I'm showing you right now, it talks about force terms, and the first one is force, any action with or without a weapon used to control or resist. Deadly force is further defined as any action with or without a weapon that will reasonably cause serious injury or death. And we'll talk a little bit more about these after we're done looking at the definitions. And non-deadly force, any action with or without a weapon that will not reasonably cause serious injury or death. And serious injury, any injury that, if left untreated, could reasonably cause permanent disfigurement, disability, or loss of use. So that's why when we're looking at these statutes and it says death or serious bodily injury, that's why it's important to understand that definition of serious bodily injury, which would be an injury, if left untreated, could result in disfigurement or death. Deadly force, again, you see it says with or without a weapon. So if you institute a chokehold or hit somebody with a lot of force in the throat, that could be considered deadly force. Or if you're pounding somebody's head on the pavement, that could be considered deadly force when there's actually no specific weapon being used other than the officer or offender's physical power. Other force terms, offender force, which will be highlighted in red, force used to resist arrest, avoid detection, or escape, and then officer force, highlighted in blue, force used to control offender resistance and avoid unnecessary injury or death. More terms, physical tool, any hand-to-hand technique used to apply force. This includes but is not limited to grabbing, pulling, pushing, punching, or kicking. And a weapon, obviously, as I mentioned before, could be a knife or a gun, but it could also be a motor vehicle, like we saw in Texas with a gentleman striking the motorcycle with a rear bumper of his car yesterday because he was illegally passing. That would be, an assault with a deadly weapon. It doesn't have to always be, the traditional gun or knife. It could also be a bottle, piece of furniture, a rock, anything could be used as a weapon. The use of force, again, is a rapidly evolving circumstances with no two events identical, and that's why it's difficult to, talk about anything in generalities or during your webinar. Every case is going to be a little bit different, how the scenario unfolds, looking at the officer's experience. What type of call was the officer dispatched to, or is it a self-initiated activity? All those things have to be taken into account when we're, looking at, how that scenario in particular unfolded. When we're, looking at how these force are used, either if it was the offender or the officer, what target was available, and that would be the target most likely on the body. Is it something that was targeting the face or the chest, arms, what specific area of the body was being targeted? What tool was being used? Was it a weapon such as a gun or knife, or was it hands, feet, head? What type of a tool was being used as a weapon? And then the amount of time that the tool was used. And we'll talk about that. It's again, very rapidly evolving circumstance. So if they see that one tool isn't working, they may have to transition to another tool. But the longer a scenario unfolds, the more injury or serious bodily injury could occur. The target variables, ability to quickly identify, evaluate, or change targets. Simply stated, the person who moves fastest tends to be more effective at using force. So on the officer's perspective, if he's trying to grapple with a person using only his empty hands and that's not working, then he will want to transition quickly to either OC spray, pepper spray, or a taser. If that's not effective or not available, then he may have to go to what we call hard-handed techniques, which would be punches and kicks and strikes, or possibly an impact weapon. But the officer normally today would have some type of less than lethal weapon that he would be able to transition to if his hands were not sufficient. Other variables, again, as I mentioned, ability to quickly choose and evaluate the effectiveness and the person's skill level with the tool is going to have a lot to do with how effective it is. So again, with the officers, normally you're going to have OC spray, taser, and an impact weapon on your duty belt. So they've got some choices to use. If one isn't working, they can transition to another. And they need to be proficient with it. The more practice they've had in training, the more competent they will, and hopefully it will cause less injury. Looking at this formula, target plus tool equals time, to effectively use force, these things come down into milliseconds. I was doing some training with reaction time and using firearms, and it takes roughly 0.35 seconds to perceive an event and start the mechanical movements to draw your weapon. And then once the weapon is out on target, it only takes about 0.25 seconds to pull that trigger. So you're talking about less than a second to do these things, but it still does take time. And knowing what part of the body you're going to have to target, the tool you're going to use, all that is adding up in there. And the more time it takes, the more likelihood the officer could be injured, or the suspect could be injured if the officer has to transition to a different tool. And just unfold those for you as I was talking. Again, the time is very important. We have to evaluate what's going on very quickly and decide, what type of tool we're going to use to take this person into custody. Am I going to be able to do it with my hands, or am I going to have to do it with the aid of some less than lethal weapon, or it could even be a deadly force encounter. It, just again depends on the scenario and what the officer is faced with. Here the quote is, "The use of force is a contest designed for two, and second place could be deadly." Just a picture of a law enforcement memorial parade in North Carolina. But unfortunately, we've seen too many law enforcement officers, killed in the past few months and basically just assassinated, sitting in their patrol car, eating lunch, places where, they're not totally aware of their surroundings, and that's how quickly these things can unfold. And hopefully that, going forward, officers will be able to be more aware of their surroundings, have better situational awareness, and then be able to respond and hopefully, save themselves. Got a stopping point here for questions. If anybody has any, she can pass them on to me.
Okay, and could all the attendees please type the passcode into the Q&A feature? Okay, our first question is, you say we look through the eyes of the officer who used force with the training he actually had, which seems subjective. Isn't the question objective, what a reasonable officer would perceive and what would a reasonably trained officer would do?
Yes, reasonableness is through that officer's eyes, and again, as I mentioned, a rookie may be able to use a little bit more force or react differently than a veteran would. Maybe a veteran officer would have been able to de-escalate the situation a little bit easier than the rookie would, because, again, looking at how law enforcement academies train the officers, they are, teaching them to, go into these situations prepared, and unfortunately that may give them an unrealistic perception of fear, and they may be quicker to react than is prudent. But that's basically what that means. So if we have a trial or a case that we're investigating, we're going to look at the amount of training this officer's had, what type of additional trainings he had besides just the basic law enforcement academy.
Okay, and what questions would you have regarding the liability of a police officer and government entity if a person taken into custody dies from positional or restraint anaphylaxis? Do you have any cases where the issues repositional asphyxia were litigated?
Yes. Again, that is going to come down to looking at the department's policy. But one of the first things that police officers are trained is that, once they've taken someone into custody, they are solely responsible for that person's well-being, and whether that means protecting that person from maybe the victims. The victims may be trying to get retaliation against the person you've arrested, protection from the officer himself or other officers, or from the victim himself. I have a case where the victim actually strangled themselves in the back of a police car while they were waiting to transport the person to jail, and the officers weren't paying attention, and now the person is a vegetable. They were able to go without oxygen long enough that it caused brain damage. So it all comes down to the officers are trained in their basic academy to know that they have to be aware of that. Most states that I'm familiar with have done additional in-service training on positional asphyxia because it has caused so many deaths in the United States. And thirdly, each department should have a policy that outlines that to the officers, that if they've had to hog tie somebody or put them in some other position other than an upright sitting position, that they have to be aware of positional asphyxia and monitor that person's well-being, make sure that they're not having a difficulty breathing, make sure they haven't aspirated anything. If they've, vomited because of this, arrest, it could be somebody who's impaired on drugs or alcohol that may vomit, or it could be just because of the physical exertion they've had to put forth in resisting the officer. They could be having a heart attack and causing some vomiting as well. But yeah, we have experience in those type of cases, and found that majority of the time that the officers didn't act prudently. They should have been more aware of the arrestee's position and monitoring their health.
Okay, the next question is, what about someone who is obviously emotionally disturbed? Is there a different standard of care?
No, that comes up quite a bit. So many deadly force encounters in law enforcement are with emotionally disturbed people. A lot of them, of course, we have the suicide by cop phenomenon, where the person will put themselves in a position where the police officer has no choice but to use deadly force. We're talking about a case just yesterday where a person shot the police officer, and the police officer didn't shoot back and told him, just because you shot me doesn't mean I'm shooting you. And the person was doing everything they could, including shoot the police officer, trying to have the police kill them. But unfortunately, what it all comes down to is it doesn't matter if the person is known to be an emotionally unstable person or somebody that's unknown to the police are going to react to that person's use of force against them. And if that person is displaying a deadly weapon with the potential to kill or serious injury them, they're going to have to utilize force. So no, there isn't a separate standard. If you have time to plan it, if you know you're going to a home or a location where you've experienced somebody that's an emotionally disturbed person on other occasions, you may have more time to plan it, respond with more officers, have officers with less lethal weapons ready to be deployed. So some of it depends on the amount of planning time the officers had. If it's an unfolding event that the officer's thrown into, then you may not have that luxury. Any others?
Okay, the next question is, may an officer reasonably allow a canine attack on an unarmed, non-threatening, non-fleeing individual?
Not under that circumstances. Normally, in my 20 years as a canine handler, the person was either being assaultive or was fleeing and ordered to stop and given a warning prior to the canine release. But if they just release the dog on someone that it isn't warranted, then that would be an excessive use of force.
Okay, what type of training is a police officer to undergo in the use of force?
Every state's going to be a little bit different as to the number of hours that they have, but in North Carolina, the officers go through a 40-hour block of training that talks about the use of force, and then annually during our in-service training, we have either a 2 or 4 hour block just on the use of force, where we review the court cases that we talked about, Graham versus Connor and Tennessee versus Garner, and also any current case laws or cases that have come along, and how that's affected law enforcement. But again, every state's going to be a little bit different, but they're going to basically cover all the constitutional requirements, and then whatever their state requirements are. And then if it's a department academy, they should go over their department regulations as well. So, of course, federal law is what is the main umbrella, and the states can make their laws more restrictive, but they can't make them any more liberal. So I would say that every officer, would have at least probably 20 hours of use of force training to go through all the different levels of force, whether they're less lethal or lethal force.
Okay, and are these laws also applicable to security guards, or is the use of force different?
The use of force is different in security guards, and again, I can only speak about North Carolina, but I'm an instructor for our Private Protective Services Board here, and security officers are only allowed to use deadly force when their life or the life of somebody else is in jeopardy. They don't have the right to stop a fleeing felon. They don't have the right to stop a person who's using a deadly weapon to effect their escape. All the things that we mentioned earlier in the webinar, they don't have that right. They, in North Carolina, have the right to use reasonable force to detain someone until law enforcement arrives. What that usually means is if they can, secure them with handcuffs or, put them on the ground and detain them. They're not allowed to use deadly force. They can't hold them at gunpoint until law enforcement arrives. They have to find some other reasonable method to do so. But yes, the short answer is security guards have less authority to use force than a sworn officer does.
Okay, we do have additional questions, but I'm going to save those for the second Q&A, so please continue with the presentation.
Thank you. The next thing that I want to talk about are the reports, and this is what you as attorneys are going to be dealing with primarily. So it's important to be able to discern what the officer actually wrote. I had a case recently where it's amazing when the officer gets up on the stand and all the things that they recall, but yet there's nothing about those topics or actions in the report at all. So the reports are always the weakest thing for the law enforcement officers, and we're always working with them trying to increase what they put in the reports and how they word those reports, because as I tell them in training, this is going to be looked at by your supervisor, and it's going to be looked at by the command staff, then it's going to be looked at by the district attorney's office, and then the defendant's attorney, and then of course if it gets appealed, it'll go on up to Superior Court, but you never know. It could end up at the Supreme Court, so we want to write reports that are, very well written, that we convey our idea, and that they use the terminology that, we have in our training and our laws. But they are our legacy letters, and these things are going to, be looked at for many years to come. But the first thing that we need to make sure are in the reports, and again, if you're an attorney for a police department and or are defending a police department or an officer, these are the things that we want to look at, in the report is, what type of activity, was unfolding in this scenario. What type of call did you receive? And, what did you do before you responded? What did you do when you get on the scene? How did it all unfold? So they need to paint a word picture. I went through a relationship seminar many years ago with a guy named Gary Smalley, and he continuously talked about, word pictures, and so I use that as well, because I want anybody that reads these reports to be able to envision what the officer was doing and what they were experiencing as they were going through the situation. Everything has to be consistent and relevant. So, it makes, it's just common sense. So what has it got to be consistent with? It's, of course, the laws. What law were we enforcing? Why were we interacting with this person? Were we within agency policy? And is this also the way that I was trained, to react in these situations? So, again, adding this information to the report is going to aid the officer as it moves through any civil litigation particularly. Quantifying reports when details are clearly defined, it's less likely to be taken out of context. We can use examples, comparisons, or definitive facts while we're writing these reports. And the way that I received my report writing training in the 70s is hopefully better than it is now, but it was always third person, and I never really cared for it. So I try to encourage officers now to use more of an active voice and be a little bit more descriptive. We want to describe the type of place that we're in, again, giving specific details about the environment. How much room do we have to react in? Is this, like the photograph of open parking garage with only one car, or is it a small mobile home living room that's jam-packed with furniture? So we need to, put these details in the report so that, again, whoever's reading it is going to be able to have a word picture in their mind and see how much room that the officer had to operate in, or if a person's with a knife and they're in an empty parking garage and there's hundreds of feet between them, or is it a crowded mobile home living room where there's only 3 or 4 feet between them? All those things can make a difference in how the officer responded to the person. Some examples of different ways to write the report. You can read that yourself, but again, same information, but one will give you a little better description of what the officer was experiencing. And same thing here. Just a few more sentences, but it really helps describe the environment the officer was in. Was the person on alcohol or drugs, or did it appear to be that the person was impaired? Obviously, the more violent subjects we deal with are normally found to be impaired on some type of a drug. They're insensitive to pain, their inhibitions are lowered. It requires more force to get them under control, which usually means that their body is going to have more injuries to it because of the force that had to be used to get them into control. But making sure that that information is recorded in the report is very important. If they've got an odor of alcohol about their breath or other chemical odors about their breath or their person, if there's drug paraphernalia found, if there's any residue around their nose or mouth, all those things need to be adequately reported, again, documenting it for future litigation. And communication is talking about, their ability to, communicate with us. Is their speech slurred or thoughts clear, or do they appear to be impaired? Being more descriptive about how the offender's body language is. If the officer writes in his report, the subject stared at me aggressively, that it doesn't tell you a whole lot, or the person acted aggressively toward me. But if we can start, describing, saying that this the defendant stared at me. He started taking off his rings, his coat, which indicated that he was preparing to fight. If he started shifting his weight on the balls of his feet, getting ready to throw a punch, again, we're painting that word picture so that we're showing these pre-assaultive clues and detailing that observation. And a couple more examples for you to read real quick. And a few more things that we want to add in there about what the person was telling us. Are they, telling us that they're going to assault us? What are they saying exactly? All that should be pretty much recorded in the report verbatim. If they just make one statement, it may not be, that indicative of what they're going to do, but multiple statements along with pre-assaultive clues, the way that they're, carrying themselves, they're raising their fists, are they staring at us, are they preparing for a punch, or they look like they're getting ready to run, all those type of things should be included in the report. Something that's being recognized now as beneficial to the report is the officer's knowledge, skills, and experience. So as they write their reports, they can talk about, what experience have they had with this type of situation in the past, if they've had any specific type of training in there, if there's any individual agency statistics about, if we've experienced this many times, the subject was doing the same type of behavior, so therefore I drew the conclusion that he was going to do it again. So it's basically what they're talking about. This was the example where I was talking about the person taking off his ball cap. As you can see where the officer wrote, "I witnessed Mr. Adams intentionally take off his ball cap, make fists with both hands, begin walking directly toward me. I have 15 years of law enforcement experience and have investigated more than 200 domestic violence cases. Mr. Adams' actions were consistent with offenders intending to resist arrest physically or with a weapon." But again, all that sounds a lot better than, Mr. Adams was acting aggressively toward me. So we're trying to get officers to be more descriptive in their report writing. Officers communicate before, during, and after the use of force. Effective reports provide chronological accounts of what was said and how many times. So the officer is announcing to the person that they're under arrest. He's giving them instructions. Turn away from me, put your hands behind your back. And then once he has a person in custody, try to explain to them, what the circumstances are. But he's giving them commands, tell him that he's under arrest, and then once he has them secured, we want to put them in, inform them as to what's going on and why they're being taken into custody. Some of the words that, we consider to be vague, again, we see these in reports all the time. You think about the last time you read a police report, you're going to hear, subject failed to obey, I advised them to do this, I told them multiple times. But again, if we use what I've been talking about today, it would be I explained to the victim or the defendant, why he was being arrested. I told him 10 times to put his hands behind his back. So again, we're just, instead of saying multiple times, we're specifically telling how many times, we've instructed the person to perform whatever the task is. And that the person's not complying with our wishes and anything else that he may be saying. Normally, people are restrained in handcuffs, but that should be in the report. A case I had recently, we had all the witnesses who were all officers sequestered. 2 officers said that the defendant was handcuffed in the front, and the arresting officer who actually applied the handcuffs stated that he put him on in the back. So what do you think the jury believed? They believed he put him on in the front, and for whatever reason, he doesn't remember, and he's just saying that he put him on in the back because that's normally what he does. But all that should be recorded in the report as well. How long the handcuffs were on there. So if the person is complaining about any, injuries to his wrists or hands, lack of feeling, that type of thing, you can say, the subject was arrested at 2:49 p.m. Handcuffs were applied behind his back and double locked. He was transported to the Wake County Jail and arrived about this period of time. So you can deduce how long the person was actually in handcuffs. And once inside the jail, handcuffs were removed for processing. Other report details need to be the type of restraints or anything additional. We talked about handcuffs, but also it could be flex cuffs. So it's a situation where multiple people are being arrested. The officers may use the plastic flex cuffs if the person is being very aggressive, and they have to put a rip hobble on them, which is a device that basically hog ties them. It ties their ankles together and then ties their ankles to the chain on the handcuffs, so it mobilizes their legs. If something like that is put on, it should be documented as well, and the amount of time that the person was in that restraint. If they had to put a spit mask on him or leg irons, anything that they do, I would recommend it be listed in the report and give a general amount of time that the person was in there and why they felt that type of device was needed. As you can see, again, it's repeating what I was talking about, but if the person was restrained, why were they restrained, and did the person, resist after he was in the restraints, because, of course, that could cause more injuries to the person as he's trying to get out of the restraints or continue assaulting the officers while in restraints. This, brings us to the end of the presentation itself. Of course, we'll, talk more about your questions and any other things that you would be interested in hearing in the remaining few minutes we have. And as I mentioned at the beginning, if we're not able to get to your questions, I'm happy to do that this afternoon and send them to you so that we'll let you go away feeling you got something out of this presentation. Again, we looked at Graham versus Connor, which was the Charlotte case, and it said if the officer is acting on what he believes to be a crime in progress or a threat, that as long as it's reasonable, then it should be okay, and that not every push or shove is a violation of the Fourth Amendment. We looked at Tennessee versus Garner, which said that shooting fleeing suspects wasn't a good thing, and that the only time deadly force should be used is, again, to save yourself or somebody else, or stop a fleeing felon if they're imposed on by a felony, or if the person's using a weapon to effect that escape. We talked about the concept of target, tool, and time, and it was, again, just a way to help to train officers and also report writing. Talked about details needed to be in a use of force report, talking about the size of the area that the event occurred in, specific language that the offender may have used, any threats that the offender may have made, as far as body language goes. All that needs to be recorded accurately in the report, as well as making sure that when the officers are writing this report that it's consistent with the policies of their agency, consistent with the training that they received in their career, and that it's also, and most importantly, consistent with what the law will allow. But that concludes, my presentation, and I'm looking forward to your questions.
And could all the attendees please type the passcode once again into the Q&A? First question is, if more than one officer is involved using force to restrain someone, does standard require the same level of detail and reporting from each officer?
No, normally what would happen is the primary officer that's writing the report would put the majority of details in there, but then the secondary or assisting officer should write a supplemental report, and that would detail the things that he did individually. So if he, say, had to tase the person, he could say, I fired my taser, the person was, given a 5-second stun, and then I placed handcuffs on him. So anything that they did individually, they should report on it. But they don't have to both do a full report. Somebody will be the case officer, and the other will be a supplementary report.
Okay, and may a department legitimately withhold relevant information such as a witness identification and telephone numbers from the claimant pending an internal investigation concerning the use of force?
It would be individual. I would talk to the district attorney, because if it's a felony situation, then all that should be disclosed. If it's internal investigation, it may be withheld until the investigation is concluded, but once it's concluded, that information, in my opinion, should be turned over to anyone else that's doing an independent investigation of it.
Is any force acceptable to use on an arrestee that is already face down on the ground? If so, what type of force?
If the person is still resisting arrest, then they can use some force to overcome it. But normally, once a person is down and restrained, all force should stop, other than picking them up off the ground and placing them in the back of a transportation vehicle. But any further strikes or anything like that would be unwarranted, unless the person was just continuously kicking and spitting or biting. They're still capable of injuring someone even with their hands restrained. But normally, once they're down and handcuffed, there's not much reason to have any force.
And how is the primary officer determined for purposes of reporting?
We operate on the contact cover method. So the contact officer is a person who is actually speaking with the defendant or the suspect, and the cover officer stands back and observes, and he's there basically to protect the other officer from other people in the surrounding area, to kind of stand back and observe, and then if he needs to go in and lend a hand, then he would do that. So normally the person that's a contact officer will be the officer to write the report, and the contact officer would write a supplementary report.
And for actions by a police officer, is the different standard of reasonableness applied based on the level of experience of the particular officer? Would a rookie officer be given more leeway in assessing whether he or she acted reasonably with deadly force?
Yes, that's what the reasonableness standard has been determined to mean. Of course, every judge can change that, but there is case law that talks about officers' experience, officer size, and officer sex as factors that would allow maybe a different level of force based on that individual. So if you look at a female officer that's 5 foot tall and 100 pounds, and she's dealing with a 6 foot tall, 230 pound man that's assaulting her and gets her down on the ground, she would be able to use deadly force sooner than a man of the equal size would. So it would be the same thing with experience. They're going to look at the amount of time and training that the officer has had. I think that's negligible as far as use of force, because it's, to me, pretty clear cut, when deadly force is authorized and when it's not. So I don't think you're going to see as much leeway there, but that there is some court cases that have laid that out.
Okay, and what if the officers are unreasonable in their actions, which would actually create a deadly force situation? That is, even if the use of deadly force is technically reasonable, what about their unreasonable actions in creating the situations to begin with?
Yeah, that was something that you'd have to litigate, but I look at that as our concealed carry law in North Carolina states that you cannot be the instigator of the situation and then use deadly force. You can't be the bully with a gun and and know that because you've got a gun, you're going to be able to ultimately win. And I would see that as the same standard that the police officers would have as well, that they can't cause the situation to evolve to a deadly force situation. It should be that they would de-escalate the situation to try to avoid it, and that would be contrary to what they should be doing.
Do you support the use of cameras on all officers? Should they be able to turn them off at will?
I love cameras, and I issued cameras to my officers several years ago. It just makes the citizen complaints so much easier to deal with, and our policy is that they turn them on when they get out of the vehicle and have interactions with people. If they would turn it off, then of course that would make you suspect of why they would turn it off. So each individual agency would have to come up with their policy, but mine would be that you leave it on until the interaction is over. So that way we've got a full account of what was actually said. But I find that having the cameras on are very valuable because one, the officers know that they're being videoed, so hopefully they're more professional than they normally would be. I would hope they'd always be professional, but if they weren't, at least they know they're being monitored. And then it also helps, citizens are usually a little bit more calm when they know that the cameras are on as well, so they behave a little better. So it makes the whole interaction more professional. But I'm glad to see it's going to be more commonplace going forward, because I think it will make a big difference in how we, look at what was reasonable through the officer's eyes. And one of the interesting things that's come about with the camera technology, the cameras that first were being produced for law enforcement had incredible vision at night and things that the human eye could never see. So when these videotapes are being played and you can see that the guy has a gun, or maybe that the situation is you think the guy has a gun from what you can see with the human eye, but it turns out that it's a Milky Way candy bar or something with a camera with infrared vision on it. And so if you're watching it as a jury, you say, well, why would they shoot that man? It's obviously a candy bar. But to the police officer, he couldn't tell. He couldn't see. So now they've actually dumbed the cameras down so that they only see as well as the human eye, so that it helps avoid that situation. So it's interesting, but that's something that's come about since cameras started using, is that they're actually trying to make sure that the camera can't see any better than the human eye can.
Okay, that's all the time that we have for questions. Like we said before, with the additional questions, we will be sending those over to Mr. Taylor to get answered for you.
Again, thank you for your time, and I hope this was very useful for you going forward.
In addition to being your best source for testifying and consulting experts, TASA also offers e-discovery and forensic solutions, free interactive webinars, cybersecurity services, day-in-the-life videos, and research reports on expert witnesses, such as the Challenge History Report 2.0, the Professional Sanction Search, and the Expert Profile 360. I want to take this opportunity to thank everyone for attending, and especially Roy Taylor for his time and effort in creating this presentation. If you would like to speak with Mr. Taylor, or if you would like to speak with a TASA representative regarding expert witness for a case that you are working on, please contact TASA at 1-800-523-2319. Thank you all again for attending, and have a great day, everyone. This concludes our program for today.